Welcome to the first video for the topic statutory interpretation. We're going to focus on the first three out of the four topic learning objectives. So we've got firstly to describe the three rules of statutory interpretation, which is going to be the main part of this video, and also to illustrate each of the three rules using case law, and also, although we're doing it with each element of the topic as we go along, I want to make sure that we also go through, for these three rules, the importance of them, or in other words, the advantages and disadvantages. Language used in statutes can cause problems. For example, the word may not be very clear in the context of the sentence. It could be that the word is particularly old in light of today's context. Or it could mean that Parliament hasn't foreseen certain situations that may arise in the future, be it because of new developments or new technology. And so again, it means for the barristers in court, the solicitors, the judge who ultimately has to make the decision, it can be a difficult process of fully understanding what Parliament meant to achieve or what they intended. So for that reason, over the number of years, there has been the development of three rules in how words in statutes can be interpreted. Now, judges haven't been able to agree on what approach to use, so for this reason there are three rules of interpretation which we need to learn about. So the first is the literal rule, the second the golden rule, and then as things developed even further, the mischief rule. And what you'll see as we go through is that the literal rule ties the court very much to the wording of Parliament and doesn't give them very much leeway to escape from it, even if it creates an absurd situation. But as each rule developed, more and more discretion was given to the judges to be able to reach the decision that they felt Parliament intended or was right for the case. So let's begin with the literal rule. Now this is where words in the Act are given their plain and ordinary meaning. And to really emphasise this, if we look back to the comments of Lord Esher in the Crown and Judge of the City of London Court 1892, he said, "If the words of an Act are clear, then you must follow them, even if they lead to a manifest absurdity." Now what he went on to say is that it's Parliament, the supreme legislative body in the UK, that has the authority to make laws. And it's not for judges who are undemocratic and not elected to actually interfere with this. So if a law led to an absurdity, a judge couldn't question it. They were simply there to enforce the laws of Parliament or the will of Parliament, and it would be down to Parliament to choose whether or not to change the Act or repeal it so that the situation was no longer an absurd one. So what's great about this topic is it's very much case example driven. So for each of the three rules, we're going to see one or two cases and how the rule was applied in the judgment of the court. So for the first case example, for the literal rule, it's Whiteley and Chappell 1868. Now the facts of the case were the defendant was charged under a statute where it was an offence to impersonate any person entitled to vote. However, in this circumstance, the defendant had pretended to be a person whose name was on the voters' list, but in fact that person had died. So in applying the literal meaning of the words in the statute, any person entitled to vote, the defendant, of course, couldn't be found guilty because dead people, literally speaking, aren't entitled to vote. So the defendant got away with it, and it was an absurd result. The second case example for the literal rule is the case of London and North Eastern Railway Company and Berryman 1946. The facts of the case were that a railway worker was killed doing maintenance work, which involved oiling the points along a railway line. His widow sought compensation under the Fatal Accidents Act for the failure for the company to provide a lookout for a husband that might have saved his life. However, when the court actually looked at the Fatal Accidents Act and the words in the Act and their literal meaning, her claim, i.e. the widow, failed because the Act stated that a lookout man was only needed or should only be provided by the railway company for men working on or near the railway line for the purposes of relaying or repairing it. Now, as I said, because her husband was simply oiling points on the line and not relaying or repairing it, as the Act stated, she was denied her compensation. So to review, the advantages and disadvantages of the literal rule. So firstly we have, it prevents unelected judges from making law. Now remember, of course, that really Parliament is the one that creates the laws, is the supreme legislative body, and judges are simply there to enforce them, to apply that law. And so by keeping to the literal rule, it means that judges don't enter that dangerous position of moving away from what Parliament intended and creating laws that might otherwise not have existed. Also, another positive is it makes the law more certain and easier to understand. So if we can think about clients being advised by their legal team before a case, simply a past case can be looked up, or a statute in this instance, and the solicitor will be able to advise their client and say, well, this is what has been laid out in the statute and this is what's going to happen, so it's certain. However, the literal rule has been criticised for a number of reasons. Not every act is perfectly drafted. So for instance, if we look at an example such as the Dangerous Dogs Act 1991, there was confusion there over the words type and breed. So what in essence is a dangerous dog, and that meant when situations came before the court, in other words cases, what decision was the judge meant to actually reach? Not every act covers every situation. Now, statutes are made, and then of course there are new developments in society, possibly even new technology and so forth. And so, for instance, if we think about the Theft Act 1968, in today's age, you can say that information over the internet can be stolen. So that's something that wouldn't have been foreseen. And if the literal rule was applied, it would mean that not every situation could be given the correct decision, and hopefully justice be seen to be done. Also, words may have more than one meaning, and the act may be unclear, so again words change over time. And lastly, it can lead to an absurd, unfair or unjust decision. And I think that generally speaking, in all the case examples you'll see for the literal rule, including the two we've just seen a few moments ago, you can say that the person in the first instance, Whiteley and Chappell, got away with it, and that was an absurd situation. And then in the second one, the Berryman case, the widow was denied compensation, which is obviously seems unjust, seeing as she'll no longer have her husband to provide for her and her family. Although of course you could think of it in another way and say that from the railway company's perspective, I'm sure they would have been pretty happy with that decision and not having to pay out any money. But again, I think most of us would agree that was a pretty unjust and unfair decision. But of course, because of the absurd and unjust and unfair situations that were arising from the application of the literal rule, the courts needed to develop another rule of interpretation that would allow them to escape certain case results. And so this is where we can see the golden rule. So it starts by looking at the literal rule, but if it can't avoid an interpretation that would be absurd or unjust, then there are ways of getting around it. In other words, there's the narrow application. The narrow application was seen in the case of Adler and George, which we'll see in a second, and there's a wider application, which was seen in the case of Sigsworth. So in our first case example, the narrow application of the Golden Rule, we see the case of Adler and George, 1964. The facts of the case were that the Official Secrets Act 1920 made it an offence to obstruct Her Majesty's forces in the vicinity of a prohibited place. Now, the defendants obstructed Her Majesty's forces in a prohibited area, but they argued that the literal meaning of the words in the Act, the words in the vicinity, meant outside but close to it. So in other words, they couldn't possibly be guilty. Now, the court realised that this would have led to an absurd result, and certainly not what Parliament would have wanted. So by applying the narrow application and the, shall we say, the second meaning of the word, of the wording, they stated that it should be read as in or in the vicinity of the prohibited place, and for that reason the defendants were found guilty. But of course the narrow application of the Golden Rule sometimes didn't go far enough in terms of solving a particular problem in a case and making sure that there was a just outcome. And this was seen in the case of Sigsworth, 1935, which would give birth to the wider application of the Golden Rule. So the facts of the case were that the defendant murdered his mother, As she had no will, he stood to inherit all of her estate as her next of kin, or, in other words, her issue, as the Act said, the Administration of Justice Act 1925. Now, of course, this was an unjust situation, and the court felt that Parliament could never have intended or foreseen that a murderer, a criminal, should benefit from the act of the crime financially. So they saw this as an unjust, an immoral, or a repugnant situation, and so they found that the defendant should not inherit his mother's estate. Now, of course, what was rather interesting about this case and this approach is the judges at this point are effectively creating law, because in the Administration of Justice Act 1925 they were effectively writing into the Act that an issue who has murdered their next of kin should not inherit, and that to this day remains the case. So to review the advantages and disadvantages of the Golden Rule, we can say that it provides an escape route from absurd literal meanings. So again, if the Golden Rule had been used in the literal rule cases that we saw, Whiteley and Chappell, the impersonation of a person entitled to vote, or the Berryman case, the railway worker that was denied, or rather the widow was denied compensation when he was killed for oiling points on the railway track, this Golden Rule would actually have prevented that and led to a more just outcome. It also allows the judge to choose the most sensible meaning of words. So again, we're seeing the court, the judge, being given a little bit more discretion to choose between the first meaning of a word or the second meaning to enable them to find the right decision in the case. And as we can see from Sigsworth 1935 case, it can avoid a repugnant situation. So again, it would have been simply immoral for a murderer to benefit financially from killing a relative, and so this enabled the court to, rather than apply that and have the murderer benefit and then hope that Parliament will change the situation, they, there and then in the case, can actually make sure that there is a just decision and they don't benefit. Disadvantages, however, it is still rather limited in its use. It is used rarely. It doesn't give judges too much discretion, as we'll see with the next rule. Again, I think that the Mischief Rule is more favoured, and later we'll see the purposive one, because judges have a bit more discretion to work within the confines of a statute, or indeed completely leave it to reach the decision they feel is the right one. And lastly, it's not possible to predict when the court will use it. Again, think about clients looking to be advised by their legal counsel. Lawyers will be unsure when a court will actually apply this rule or not, and this can make the law, or rather the law can begin to become a little uncertain. The third rule that we're going to look at is the Mischief Rule. Now this rule, compared to the literal and golden rule, gives the court, the judges, even more discretion to be able to find a particular decision that they feel is the right one. This originated from Hayden's case in 1584, and the court has to consider 4 specific points or questions. So firstly, what was the common law, i.e. the case law, before the act in question? What was the mischief that the case law, the courts, weren't able to fix? Thirdly, how did Parliament, through the statute that they've created and is before the court today in this new situation, how did they attempt to resolve it through that particular Act of Parliament? And fourthly, why did Parliament want to resolve it? What was the problem, and what were the benefits of Parliament actually seeking to fix it? The first case example for the Mischief Rule is the case of Smith and Hughes 1960. The facts were that 6 women were charged under the Street Offences Act 1959, where it was an offence for a common prostitute to loiter or solicit in a street or public place for the purpose of prostitution. However, the problem facing the court was that the prostitutes were not in a street, as the statute outlined, but rather on the balcony, attracting the attention of passer-bys. Now, the court, under a literal interpretation, if it had been applied, would have meant that the prostitutes would have been found not guilty, and therefore the court applied the Mischief Rule and the 4 points in Hayden's case, and believed that the intention of Parliament with the Street Offences Act 1959 was to essentially clean up the streets and not to allow prostitutes to interfere with law-abiding citizens. So for that reason they found the prostitutes guilty under this rule. Our last case example for the Mischief Rule is the case of Royal College of Nursing and DHSS 1981. The facts were that the law under the Abortion Act 1967 only allowed a doctor, or as the statute outlined, a registered medical practitioner, to undertake an abortion procedure. However, advances in medicine, in particular drugs, meant that the drug could be administered by the doctor as the first part of the process, and the nurses could perform the rest of the abortion procedure afterwards once labour had been induced. However, nurses were not deemed to be registered medical practitioners, as the statute outlined. The court had to decide whether this new procedure was lawful. Well, in terms of the decision that the court made, which reached the House of Lords, there was a bit of a split. The House of Lords decided by a majority of 3 that it was lawful, with 2 dissenting. And what's really interesting about this case is that clearly the judges were making law in this instance, but it also meant that the role of a nurse was going to fundamentally change, and there was some dispute over some nurses who had joined the profession and felt that it wasn't the right of the courts to actually deem what they should or shouldn't do when it might be morally against their own wishes. To finish then, the advantages and disadvantages of the Mischief Rule. Firstly, we have that it promotes the purpose of the law. I mean, clearly the Mischief Rule, and part of the examination with those questions from Hayden's case, is that Parliament, the courts, are looking to see what Parliament wanted to achieve, what they intended. And of course the other part of the Mischief Rule is, once they've identified what they believe Parliament intended, is to then try and apply it to the gap in the law that they face in the case before them today, and usually then it will produce a just result. Also, another advantage, that judges try to interpret the law as Parliament meant it to work. So whilst there's still more discretion for judges here, and they're trying to discover or interpret what Parliament meant, it's not solely based on their own views or their own beliefs, because they're still tied down to looking at certain sources. Now that could be dictionaries of the time, it might be in certain cases or circumstances, if allowed, the use of Hansard and to see what was debated in Parliament. So there are still some pieces of evidence that they have to examine. Of course, as well, the Law Commission prefers the Mischief Rule and has recommended so for a number of years. Now, disadvantages. Obviously now, as we've worked our way to the third rule, the judges have more and more discretion, and this means that there is a danger that the original intention of Parliament could be left further behind, if you will. So there's a risk of judicial lawmaking. So yes, even though that they're tied to, for instance, looking at dictionaries of the time or Hansard, for example, effectively the judge is trying to, as best guess that they can, if you will, say what they think Parliament meant. And of course that might not be the case. It is a bit of sort of deductive logic there. I mean, secondly, judges are filling the gap in the law with their own views and not all agree, and we saw that, for instance, in the previous case of the Royal College with the Abortion Act 1967. Again, law was made and it fundamentally affected the roles of nurses, some nurses of which joined the profession and knew that they wouldn't be involved in an abortion procedure, but now, of course, the House of Lords, albeit by a split, 2 dissented, decided that yes, that would be the role of a nurse. So you can see how, just from that case, 2 disagreed. It's really a fine line. Thirdly, it can lead to uncertainty and difficult for lawyers to advise clients as to the law. And again, we've seen that as we've gone along. If it's not simply going by what's written down in the statute, which in essence is the literal rule, the plain and ordinary meaning of the words, then it becomes an even greater challenge for lawyers to be able to advise their clients as to what direction they feel the court might take. And also, we can say that it's not as wide as the purposive approach. Now that's something I'll look at in the next video with you. and that is even more discretion. But though it's not as wide as that approach, it's limited to looking at what the gap in the old law was. So again, specifically tied down to what did the statute, what was it intended for, what remedy were Parliament trying to supply. Again, it's very fixed to those questions and might not, in some instances, go far enough to resolve a situation and avoid an unjust or unfair decision. Thank you for listening.